What is VTL Section 1192? 3. Driving while intoxicated, DWI. Driving while intoxicated under New York's Vehicle and Traffic Law Section 1192. 3. Is a serious criminal offense. A conviction shows that a driver operated a motor vehicle while substantially impaired by alcohol. Consult a lawyer quickly. Acting fast with an experienced legal advocate can protect your license, freedom, and future. A defense lawyer on Long Island can evaluate evidence, challenge the stop, and protect your constitutional rights. Section 1192, 3, states that no person shall operate a motor vehicle while in an intoxicated condition. It is called Common Law DWI because it predates breathalyzer technology and relies on observations rather than a specific blood alcohol concentration. Prosecutors may rely on officer testimony, field sobriety tests, and other signs of intoxication. By contrast, Section 1192, 2, per se, DWI, requires proof of a blood alcohol concentration of 0.08% or higher. Under Section 1192, 3, no chemical test is required, so the charge can be brought even when no test was given or test results are inadmissible. Prosecutors must prove two elements beyond a reasonable doubt: that you operated a motor vehicle and that you were intoxicated. Operation does not always require driving. It can include sitting in a parked car with the engine running. The alleged offense must occur on a public highway, private road open to traffic, or a parking lot open to vehicles. Intoxication means consuming enough alcohol to be substantially incapable of using the physical and mental abilities expected of a reasonable driver. Evidence can include visible impairment, the smell of alcohol, poor field sobriety test performance, or erratic driving. Penalties are severe. A first conviction is a misdemeanor that can lead to up to a year in jail, fines, license revocation, ignition interlock installation, and completion of an impaired driver program. A second conviction within 10 years is a felony punishable by up to 4 years in prison, higher fines, and longer revocation. Third or subsequent convictions can mean up to 7 years in prison and larger fines. The Department of Motor Vehicles may impose separate sanctions. In refusal cases, a hearing officer may revoke your license for a year if police had grounds to suspect a DWI and you refused a chemical test. Courts may also suspend your license at arraignment if a chemical test shows a blood alcohol concentration of 0.08% or higher. During a revocation, a conditional license may be available through the impaired driver program, but not if the DMV sustains a chemical test refusal. Common defenses focus on whether police had a lawful basis for the stop and whether their observations are reliable. If officers lacked reasonable suspicion or probable cause, evidence obtained afterward may be suppressed. Because Section 1192, 3, cases rely on subjective observations, your attorney can challenge inconsistent reports, improper sobriety testing, medical conditions that mimic intoxication, inadequate documentation, or statements obtained without proper Miranda warnings. Field sobriety tests must follow standardized procedures and be administered under appropriate conditions. In chemical test refusal cases, police must clearly explain the consequences of refusal. Failures can provide grounds to challenge a suspension. The effects of a Section 1192, 3, conviction extend beyond the immediate penalties. A criminal record can damage employment prospects, threaten professional licenses, affect immigration status, raise insurance costs, hinder international travel, and influence child custody matters. Legal representation is essential. An experienced DWI attorney can analyze the evidence, identify weaknesses in the prosecution's case, challenge constitutional violations, negotiate for reduced charges or alternative sentences, represent you before criminal courts and the DMV, protect your rights, and pursue dismissal or acquittal where possible. Navigating local courts such as the 1st District Court in Central Islip, the 2nd District Court in Islip, or courts in Riverhead requires knowledge of local procedures and relationships with prosecutors and judges. Although a Section 1192, 3, charge is daunting, A knowledgeable defense advocate can help you fight the allegations and minimize the consequences. If you or someone you care about is facing a DWI charge on Long Island, contact the law firm known as the Law Offices of Jason Bassett, PC for representation. The law firm is located at 320 Carleton Avenue No. 4200, Central Islip, New York, 11722, United States, and can be reached at 631-259-6060.